So people will start to file in. I will give everybody about another 30 seconds, and I'll introduce you, and we will get started.
Okay, great. And Paul, I'd love to, if we have time afterwards, I'd love to hear about what you're working on too. So we can play it by ear, but you're working on a lot of great stuff. So.
Right. Well, good afternoon, good morning, and good evening to all of you, and thank you for joining us for the last installment of this year's Administrative Law and Governance Colloquium. And today I'm joined by Professor Jennifer Ngo of the University of Chicago Law School. Her research interests include administrative law, executive branch dynamics, regulatory policy, and constitutional separation of powers. She's been a part of the University of Chicago Law School since 2018. Her educational background includes a BA from Yale College, an MPhil in politics from Oxford University, and a JD from Yale Law School. After law school, she was a clerk to Judge Richard Posner of the U.S. Court of Appeals for the Seventh Circuit, and then to Justice Stephen Breyer of the U.S. Supreme Court. Prior to joining the faculty, she was a public law fellow at the law school and also worked as a policy analyst and special assistant at the Office of Information and Regulatory Affairs, OIRA. Professor Ngo is currently a public member of the Administrative Conference of the United States, and some of her publications can be found in the Harvard Law Review, Columbia Law Review, the Yale Law Journal. She's also done editorial work for the Harvard Law Review, Journal of Legal Studies, Journal of Law, Economics and Organization, the Political Science Quarterly, the University of Chicago Law Review, and the Yale Law Journal. She is going to speak to us today about her work on bureaucratic resistance, a very well-known and thought-provoking article about the work people do in public administration and the extent to which sometimes it might deviate from the visions of those at the top of the hierarchy. Professor Ngo, thank you very much for joining us. I'll hand it over to you. You speak for maybe 40 minutes, and we'll move into Q&A after that. As ever, attendees, if you have questions, put them in the Q&A, and I will relay them to our distinguished guest. So Jennifer, over to you.
Thanks, Paul. Well, thanks so much for that introduction. And it is a real treat to be here. It's one of the silver linings, if you will, of all of this, to be able to speak to people, across borders like this. So as Paul said, I will speak for about, a half hour or so, but I'm really eager to for the discussion and to hear from all of you on what I think is a really difficult topic, one which I think my own thoughts are very still tentative on. I struggle with a lot of the trade-offs that the topic raises. And in addition to that, many of my examples and the motivations, while they are US centric, I am eager to hear about the Canadian experience. And I believe that the themes are broader and more general and hopefully still interesting. So the topic that I'd like to explore with all of you today is a topic that I have called civil servant disobedience. And civil servant disobedience, and I'm going to unpack this definition, but just to kind of get our feet wet, entails conscientious public acts of dissent by civil servants that violate internal agency norms or directives in an attempt to bring about political reform. And drawing on the literature on civil disobedience by private citizens, I really hope to explore kind of two questions today together. The first is there a set of social practices that can usefully be grouped under this heading of civil servant disobedience? Is this a phenomena that occurs and that can be picked out in the real world and identified? And then secondly, when is this social practice legitimate, if at all? So with that framing, let me just introduce some slides here to illustrate some examples. So here's the definition. Once again, these are my questions. Okay, so I want to start with just the analogy to civil disobedience. Okay, so just as political philosophers have been debating the legitimacy of civil disobedience by private citizens, the paper's premises is so too is the need to consider whether disobedience by civil servants is normatively justified in a democracy. And of course, this is Mahatma Gandhi, an exemplar of civil disobedience. And both civil disobedience and civil servant disobedience raise the more general problem, okay, of overt political disobedience, the question of when actors can openly defy duly elected or appointed officials. Okay, both civil disobedience and civil servant disobedience arise in this context where rules, whether they be managerial or legal, underlie a regime's legitimacy. Okay, whether it be in a democracy or in a bureaucracy, right? These kinds of disobedience really threaten both of those orders. And it's this flouting of these background premises that's our topic of interest today. On the other hand, while drawing this analogy, it's important to recognize the differences between these two contexts and therefore the different normative conclusions that we might arrive at. So disobedience by public officials versus private citizens arises in a context of hierarchical deference, right? There is no question that bureaucrats, unlike private citizens, or at least in ways that are different than the relationship between private citizens to their elected officials, are much more hierarchical, right? Weber's ideas of hierarchy and authoritarianism within the bureaucracy are much stronger. Civil servants, unlike private citizens, they occupy impersonal offices from which they can resign. But at the same time, civil servants also usually possess specialized expertise, and they may have privileged access to politically relevant information in a way that private citizens don't, in which case we might think civil servant disobedience is even more justified than civil disobedience. But before we get too far ahead of ourselves, first, let me just isolate the category of civil servants. Okay, so in the US, this is the UK, but in the US, just to kind of get a picture in our heads, in the US, I'm talking about a category of public officials that are, of course, separate from the appointees. And they're usually hired into the federal government through a merit system. There is either, an examination process or a hiring system through impersonal neutral criteria. And the important piece of this is that civil servants persist across presidential administrations. They're often called career civil servants because they enter the government and this is their career, right? They're not just appointees, looking to influence government for about 2 years or so. They remain, and their loyalties are to Constitution and statutes, and not necessarily the elected president. That is, when they take their oath of office, they swear it to the Constitution and the laws. In Canada, as I understand it, I think this category, and I hope Paul corrects me if this is not the right analogy, but as I understand it, cabinet ministers are all sitting members of parliament, and they're chosen by the prime minister. And it's the Public Service Commission Board, which appoints the deputy ministers and other senior bureaucrats that are charged with the day-to-day operation of agencies. And as I understand it, these are the professional bureaucrats that are selected for their knowledge and experience, and they too will serve under multiple cabinet ministers of both political parties, and they're expected to be nonpartisan and politically neutral as a result. Okay, so I hope I've isolated. I'm looking at Paul. He's not shaking his head, so that's good. I hope I've isolated the analogous kind of category of bureaucratic officials that I have in mind when we think about together, when is it okay for them to openly flout and disobey their political superiors, presidential appointees, members of parliament, ministers? Let me illustrate by giving you some examples of this particular phenomena in the US. And in some ways, I think this topic feels almost quaint because it was so much a feature of the Trump administration that, at least in the US and the Biden administration, I feel like the topic almost feels antiquated. But I'm going to suggest that actually it's not, that it's a feature of many presidential administration and has been a historical feature of the US. Although the claim that I make in the paper is that the extent of the open defiance was at a zenith, I think, in the Trump administration, but it is still something, again, that persists, and we have to think about. So let me give you some examples of this phenomena, okay? So this is what's infamously known here in the States as Sharpiegate. Okay, I don't know if it made it up rather to Canada, but essentially this is an example when Hurricane Dorian was bearing down in the southern US, and President Trump had announced that the hurricane was going to hit the state of Alabama. Okay, so this is down here, and the map his expert gave him didn't match his tweet, so President Trump conveniently took out his Sharpie and changed the hurricane's path on this map, okay, to the horror of the professional bureaucrats within the National Weather Service. This is the NWS Birmingham in Alabama. And they tweeted out in open defiance of President Trump's changed map that, in fact, Alabama will not see any impacts from Dorian. We repeat, no impacts from Hurricane Dorian will be felt across Alabama. The system will remain too far east. Okay, so importantly in this example, the civil servants are identifying themselves as such. Okay, this is not in the name of the political appointee per se. It is open, it is public, in defiance of the president's claims to the contrary. Some other examples. This is closer to home for me. This is Chicago. And this was a really kind of striking scene, at least to my eyes. Okay, here you have the civil servants and the Environmental Protection Agency openly protesting as such. Okay, many of them, you can't really see them easily, but a lot of them are identifying themselves as part of the EPA during their lunch hour to protest the nomination of Scott Pruitt, who they perceived to be unfriendly to the agency's mission. Okay, again, it is public, it is open defiance of an potentially incoming presidential appointee. And now, again, lest you think that this is just something that occurred in the Trump administration, there are already potential signs that this persists even now. Okay, so this is Betsy DeVos. She is was the head of the Department of Education under Trump, and she urges her career staff to be the resistance as Biden takes over. Okay, so lest you think that this is just about the Democratic Party kind of resisting the Republicans. Well, Republican appointees too. What's good for the goose is good for the gander. Okay, they too are going to are encouraging their civil servants to resist. And I think the agency most likely to engage in civil servant disobedience under the Biden administration is ICE, the Immigration, Customs, and Enforcement. These are the immigration agents within the US, as Biden tries to radically change Trump's immigration policies. ICE officials have historically been very resistant to efforts to do that. Okay, and perhaps most infamously, this is under the Obama administration, the 10 ICE agents actually sued the government over the program that's here known in the States as DAPA and DACA, the Deferred Action for Parents of Americans and the children of these officials. And the point here of this is, again, that it was open. Okay, these career bureaucrats in the immigrations and customs enforcement were flouting the direction by the Department of Homeland Security head to defer enforcement of the immigration laws for a particular class of individuals. Okay, so much so, not only did they openly defy the order, but they went ahead and sued the administration itself. Okay, so I looked for a bit for Canadian examples, okay, and I found this headline where top bureaucrats met to resist partisanship imposed on the public service. This was in 2015, but I imagine that this is not a shocking headline to some of you. The deputy ministers had gathered in May openly, okay, there's a whole media article about this, to discuss creeping politicization of the federal public service. Okay, so I believe there's probably reason to think that it occurs there as well. Now, let me acknowledge that, this idea that career civil servants don't match in lockstep with political appointees, not only is it hardly a new phenomena, but it's really, I think, not surprising once you consider the decades of scholarship and just kind of common sense of principal-agent problems, right? Like all the reasons that agents will shirk or drift, to use the terms from the literature. But, there's like a lot of reasons why, agents won't always follow the preferences or abide by the preferences of their principals, sometimes because they're uninformed about the preferences, right? Principals need ways to communicate the preferences to their staff when they're not publicly, out in front about it. So sometimes there is preference divergence as a result. In addition to that, look, bureaucrats have a reputation for not always, for the stereotype is that they're lazy and that that they're out the door at 5 o'clock here in the States, and so certainly they have reasons to shirk. Okay, and when there are resource constraints, bureaucrats themselves and civil servants themselves have to prioritize kind of their resources, and sometimes that prioritization doesn't always follow the directives and the priorities of the principals themselves. And then finally, in addition to that, of course, we also know that sometimes agents just have different preferences than their principals. Okay, so it is no surprise that many apply to particular agencies because they're very excited about their mission. So, for example, environmentalists committed environmentalists will apply to work at the Environmental Protection Agency. And when they're met by a political appointee that is opposed to the mission of the EPA as understood by the environmentalists, well, gosh, there's also going to be this preference divergence. Okay, let me just unpack my definition of civil servants' disobedience a little bit, because again, the aim of this paper is to be a little bit more careful about the terms of the debate. Instead of talking about the deep state or the resistance, can we be a little bit more careful about this particular phenomena of resistance? Okay, to be clear, civil servant disobedience is just one form of bureaucratic resistance. There's many other forms that it can take. Okay, but the one that I want to talk about is something that is the kind of activity that is conscientious. Let me start with that idea. Okay, so conscientious refers to the notion that the motivation for the civil servant's disobedience must be made in good faith. Okay, that is, it can't be in pursuit of selfish private ends or their own policy preferences. If it's in pursuit of their own policy preferences, well, that's just called insubordination. Okay, that's not, I don't categorize that as civil servant disobedience. Okay, the civil servant has to make a good faith motivation for wanting to bring about some kind of political reform, some public end that they think is justified. We're going to talk about what justified means, but the important point is it can't be for selfish or purely private gain. As I've mentioned multiple times, this phenomena also has to be public. Okay, it refers to open dissent by civil servants in their official capacity rather than as a private citizen. By contrast, okay, covert acts to withdraw from helping a particular administration might be better called conscientious objection. Okay, so here I have the example of, sometimes there are career attorneys within the Department of Justice here in the US where they refuse to sign a legal brief on the grounds that they disagree with the legal arguments. They think that, that they're not, plausible. They think they're frivolous, so they refuse to sign it. Okay. And I don't want to call that civil servant disobedience. Okay. I'm going to call that conscientious objection, because the purpose of doing something like that is to maintain one's own sense of personal integrity rather than to bring about public political reform. Okay, so I think that's something different. Okay. And so it's important that this is public dissent. And then in addition to that, it is important that there is something law-breaking about the activity. Okay, so again, civil disobedience that we're more familiar with, right, has law-breaking at its core. Similarly, civil servant disobedience must be in violation of some internal agency directive. And I've become squishy. I've also put in norms here. We can talk about whether that's appropriate or not, because I think that there are things that are understood where there might not be an explicit directive to do something, but yet the civil servant knows that it's breaking a norm, for example, by leaking to the press. Okay, that's a bad example because I want to actually say leaking is not civil servant disobedience. But my point is that there are norms that are in place, okay? And that we maybe we'll have a discussion about whether that's the right understanding of law breaking. And what I have in mind here is a vein of scholarship here in administrative law work where, Kevin Stack and Jillian Metzger talk about, these executive directives as a form of law. Okay, so the point is that, again, it has to be law breaking to count. Okay, let me again distinguish civil servant disobedience from a couple of other kinds of bureaucratic resistance, just to make sure I've isolated the conceptual category that I'm interested in. Distinguish something called uncivil obedience. Okay, this is what David Posen and Jessica Bowman-Posen have identified as covert acts that don't violate laws or norms. Okay, so when civil servants, for example, are merely slow walking their orders, okay, I'm not going to call that civil servant disobedience because they're not law breaking. Okay, they're working to rule. They are, complying with the directive. They're just not doing it enthusiastically. Okay, so my example in the paper is, we have people at the USDA. They're not advocating for the Reagan policies to, call ketchup a vegetable for the purposes of school lunches, right? They're not advocating for it, but they're going to be, talking the line. Okay, that's not civil servant disobedience. That's uncivil obedience to the rule. I also want to distinguish conscientious disobedience. Okay, now here what I mean is if there are covert acts of public protest, for example, when people leak, I don't want to call that civil servant disobedience either because it's anonymous. We're not sure who is doing the leaking. Okay, and while it is a form of protest, okay, it is anonymous and therefore it is not civil servant disobedience. And then finally, I'm going to distinguish something called rule departure, where this is a case where, career prosecutors, for example, will exercise their discretion and not enforce a law, right? That's just departing from the legal rules, but it's not a form of civil disobedience because prosecutors have the lawful discretion to do so. So there's no law breaking involved. And so again, it's not civil servant disobedience as I define it. Okay, so if I have managed to convince you that there is some social phenomena that's worth isolating called civil servant disobedience, okay, now let's just ask, under what conditions is this act legitimate? Okay, so let's just for a moment return to my proposed analogy to civil disobedience. Okay, this is a slide of Martin Luther King Jr. One has a moral responsibility to disobey unjust laws, he says. And in the context of civil disobedience, okay, that practice is sometimes justified with respect to either the liberal idea that civil disobedience is necessary to vindicate some kind of higher order law, whether it is equality instantiated in the Constitution, or alternatively, it's sometimes justified as a need to perfect democracy from within. That is to say, civil disobedience is justified when there are populations that have been excluded from the democratic political process. Okay, so here in the U.S., historically there have been many efforts to, disenfranchise African Americans, certainly during the Civil Rights era, through many particular laws. And some people argue that those are worth breaking because they are keeping people out of the democratic process, people that deserve to be a part of the democratic process. And so analogously, I think it'd be fruitful to think about now civil servant disobedience, to ask whether there too it could be justified as a form of bureaucratic process perfection. Again, analogous to this notion of democratic process perfection for civil disobedience. I want to ask, well, when the internal processes within a bureaucracy have been violated, okay, maybe there is space for civil servant disobedience. And then the question becomes, well, what is an ideal form of bureaucratic process? Essentially, the paper posits that one way to think about this perfect form of, well, not perfect, but idealized notion of bureaucratic process is what it calls a reciprocal hierarchy. Okay, this notion that not only is bureaucratic management top down, but it's important that the processes in place to allow for civil servants to share their views, okay, are also robust. And I argue that this is justified from many different conceptions of administrative legitimacy, okay, whether it's this notion, the civic Republican view that internal deliberation within the agency is what justifies otherwise unelected bureaucrats from exercising coercive power over private liberties and rights, or this pluralistic notion that, when interest groups bargain, that interest group bargaining is what justifies administrative agency action, or also the notion that expertise of the agencies is also what justifies agency action. All of these forms of administrative legitimation, I argue, have at their center this notion of a bureaucratic process, this reciprocal hierarchy. Civic Republicans require, again, the deliberation between civil servants and their superiors. This often takes the form of clearance processes within agencies. Many of you that worked in agency will be familiar with this, right? It's this notion that particular decisions have to be signed off on by various offices within the agency to show agreement and assent and deliberation within the agency. Pluralism too requires civil servants that have relationships with interest groups, right, to bring the bargains to the attention of the agency heads. And then civil servants are often the carriers or the institutional instantiations of expertise within agencies. Okay. So the notion is that this reciprocal hierarchy is necessary for administrative legitimation. And it's when these processes have been violated, again, that there might be more room for civil servant disobedience. So for example, under the Trump administration, many of these processes were violated. Okay, civil servants were sidelined from various decisions within the agency. They were transferred to agency offices, to the equivalent of Siberia, where they just could not influence, DC decision making, or many of them were assigned to something called, it was the FOIA surge. It's the Freedom of Information Act. Kind of, this is a process in which people can petition for information from the government, and these civil servants who were normally working on climate change policy were assigned to deal with FOIA requests, the surge of FOIA, and therefore, again, not to actually bring their expertise to bear on policy questions. This condition alone, however, of reciprocal hierarchy, I don't think is sufficient to justify civil servant disobedience, because I think that there are situations where even when the processes are being honored, where there still might be substantive grounds for disobedience. And more importantly, there are other conditions that should be in place to ensure that bureaucratic resistance is cabined within the legal structures of the administrative state. Let me just tell you what I mean by that, okay, briefly. First of all, the statutes that authorize the agency action have to require some role for civil servants. For example, they might be expertise forcing statutes, calling, let's say, for the best available technology, where civil servants actually have a role. By contrast, if there are statutes that don't really require civil servants to be involved. For example, there are many agency decisions that are committed to agency discretion under the APA, the Administrative Procedure Act, where it's just completely a decision that the agency head can make. So for example, hiring and firing decisions within national security agencies has been understood to be committed to agency discretion. And therefore, civil servants, even if they disagree with the hiring or firing decision, I don't think there should be a role for civil servant disobedience, because the statutes themselves don't actually create space for civil servants to have a role. I also want to argue that civil servants only have a role when they are adhering to their professional norms. Okay, so my example here is, there were a lot of civil servants who spoke out against a particular nominee for his personal life. They disagreed with ways that he had treated, I think in my example, it treated women in particular contexts. And, I want to say, look, civil servants don't have a role to weigh in there, because it's not about their own professional judgments that are being brought to bear. Okay, so in other words, civil servants, their personal opinions or things that are outside their realms of expertise. I don't think that there should be a role for those judgments to be brought to bear. Okay, importantly, I want to say civil servant disobedience also has to be a measure of last resort. Okay, in other words, civil servants had to have already gone through the normal channels of dissent within the executive branch before their attempts to flout an executive order are justified. Okay, whether that's through a process of the inspectors general here in the US, or through normal dissent channels. And the State Department, for example, has its own dissent channel. Those have to be exhausted first before they can engage in civil servant disobedience. And then finally, civil servants have to be willing to accept the legal consequences of their disobedience in order to be justified. Okay, finally, and I don't want to speak for too much longer, I want to think about, I think, one of the most challenging questions in this topic, okay, which is the substantive grounds for civil servant disobedience. And the challenge here is to balance the need for managerial authority in a bureaucracy. Because what we don't want is a situation where there is endless debate within a bureaucracy about whether a particular agency action is illegal or violates scientific integrity or is immoral, right? There has to be some stop to the debate, some stop to the deliberation, okay? In order to, again, ensure that agencies can function according to their hierarchies, okay? And here I wanna, and it's this motivation that makes me think that maybe one ground for civil servant disobedience is that of clarity, okay? Now this is really hard because, obviously what is a clear example of illegality or something that's clearly immoral or clearly a violation of scientific integrity is difficult to isolate. But there are pockets of the law that might help give us concepts to think about it. Okay, so first of all, scientific integrity. I think it's much easier to justify clear violations of scientific integrity, if only because there are much more robust avenues of peer review in the scientific process. That is to say, I think civil servants have a much stronger grounds for saying that an agency has contravened scientific consensus because, again, of these other mechanisms. Now, what does it mean for a political appointee to be engaging in clearly illegal behavior? So I think that there are some pockets of the law, like I said, that we can look to. Okay, so in the context of qualified immunity here in the U.S., there's this notion of what is clearly established law. Okay, and here the Supreme Court has attempted to clarify that a clear law does not require a case directly on point, but, quote, existing precedent must have placed the statutory or constitutional question beyond debate. The law, in other words, cannot be defined at a high level of generality, but must be particularized to the facts of the case. Okay, so just to give a quick example, okay. Here in the US, President Trump signed an executive order. This is the infamous Muslim ban, right? That banned foreign nationals from 7 predominantly Muslim countries. And in 6 months later, the Supreme Court stayed the, well, it forbid the government from applying either the 90-day ban on nationals and to any individual who could credibly claim a bona fide relationship. Okay, the point just is that the Supreme Court weighed in and said, look, it is the executive order is clearly illegal, okay, at least before it was revised, right, if it was applied to any individual who can claim a bona fide relationship with a person or entity in the US. Yet, there were reports that ICE officials were nevertheless still deporting individuals under the Muslim ban, the executive order. And I want to say that those were unjustified examples of civil servant disobedience because they were not, the executive was not, there's a lot of double negatives here. The Supreme Court had already placed beyond a legality a portion of the executive order. Okay, and therefore that was now clearly illegal, and therefore it was not justified for the civil servants to be still abiding by the Muslim ban after it was illegal. Okay, now a converse of that would be an example where something wasn't brought to bear by the Supreme Court yet, and then we'd have a contest of whether that was a clear example of illegality or not. And I think there too, civil servant disobedience would not be justified. Okay, now if there is some tools there for thinking about clear illegality, it becomes really difficult when we then move to the realm of morality as a grounds for civil disobedience. Because I think the criticism of focusing too much on legality and legalism is the specter of legal positivism, which in William Simon's words, it could bless compliance with jurisdictionally adequate but morally evil laws like Nazi enactments to report Jews. And so the challenge here is to think about, well, are there grounds where a civil servant could think that in agency action by an appointee is clearly immoral and therefore should be the basis of civil servant disobedience? And we might think of things like the family separation policy as an example of something that is clearly immoral. Okay, but certainly there are views on both sides of this issue, which just highlights how difficult and how stringent this notion of what is clearly immoral is or is not. And I'm more worried about morality as a basis for civil servant disobedience, precisely because it is much more difficult to isolate something that is clearly immoral or not, relative to, legal positivism, which at least you have some texts or something more concrete in which to be able to argue that there is a real basis for civil servant disobedience. Let me end on just considering one objection to civil servant disobedience writ large, okay? And that is the objection that civil servants, unlike private citizens, can resign. So many people would say civil servant disobedience is never justified because they should just resign, all right? Not disobey, just leave. And I want to say that objection is complicated because Once again, civil servants take an oath, not to the president, but to the Constitution. And if they resign, then they are should be fairly confident that there's another civil servant who will take their place. So perhaps the oath requires them to stay and to disobey rather than to resign, which is unlike in the private context of civil disobedience. And then finally, I'll just say, look, Congress has also designed a number of whistleblower statutes, which at least suggest, let me clarify, these statutes prohibit adverse personnel actions for refusing to obey an order that would require the individual to violate a law. In other words, Congress itself has sought to encourage rather than discourage disobedience despite the potential cost to agency management. And then also note, finally, that exits can be expressive exits, to use Janet Kirkpatrick's phrase, right? These can also be very communicative acts when they resign en masse or with flaming resignation letters that are also very disorderly to agencies and agency morale, okay, and therefore might not always be the right answer to solve the problems that exist with civil servant disobedience. And so to take a step back, I think we have to think about the dynamic effects of civil servant disobedience. Even if there are democratic benefits, there are certainly long-run costs because these internecine conflicts erode the norms of professionalism that have historically defined the civil servants, but it also weakens the presidency. Okay, presidential policies post-Trump may not be as informed nor as effectively executed without a loyal civil service. And so I think the pressing question going forward now may therefore be how to restore mutual bureaucratic trust such that hopefully civil servant disobedience becomes a thing of the past. Okay, with that, I look forward to your questions, comments, disagreement, thoughts.
I had double muted myself with both the headset and the computer. Thank you very much for that, Professor No. A fascinating presentation on a fascinating topic. I see that one of the attendees has given us a link to Gilles Paquette's book on Scheming Virtuously, a handbook for public servants, a collection of practical tactics that will help public servants foster a more collaborative and innovative public service culture while upholding core public service values, regardless of where they sit in the hierarchy. And there certainly has been renewed interest in scope for civil servant disobedience or pushback in Canada in recent years, and we've had a few cases. A couple of particularly notable cases went to the Supreme Court about civil servants engaging in or wanting to engage in partisan activities, and some of the commenters might have questions on that, but I can see that Richard Clements from Tilburg in the Netherlands has a question. Nice to see you too, Richard. So he asks two questions. One, Professor No, could you elaborate more on the divide between conscientious acts as disobedience and insubordination? And then on conscientious objection, he refers to its roots in resistance movements across the world, for example, avoiding conscription in wartime. And he wonders whether the definition of civil servant disobedience has been depoliticized here, allowing it to be taken to be done within and in favor of existing state institutions, as opposed to outside those institutions in favor of a clear political project. Anti-imperialism in the Vietnam case, or defunding the police in the case of Black Lives Matter. It seems, he suggests, that bureaucratic process perfection still works within a system, whereas the latter examples do not. So could you elaborate more on that depoliticization of the term and the role of historical meaning in your use of these terms, disobedience and resistance? A nice, easy softball question for you to start with.
Yeah, no, these are two very important questions. Okay, so let me take another shot at kind kind of thinking about whether there is room in between these two concepts of insubordination and conscientious objection, though I certainly invite follow-up, and I wish we had a way to talk about it more deliberatively. But okay, so as I see it, again, the difference is when something is conscientious, okay, it's a genuine effort by the civil servant. What I mean by genuine is they have a good faith basis for thinking that the executive order or directive is illegal or a violation of scientific integrity or immoral. And one thing that I didn't note is I think that there can be more support for the civil servant that their action is justified if they have gained an opinion, a legal opinion, from the general counsel's office within the agency or the Office of Special Counsel here in the US. And I think the benefit of something like that ex post as well is that it will foster, again, more of this kind of internal deliberation. Okay, so again, the notion of conscientiousness is really a sense that the civil servant has really tried to suss out, is this just my personal belief? Or is there really some basis that is shared by other institutions within the agency, like the general counsel's office, of my judgment that what is going on is really illegal? And so again, if it's, scientific integrity, are there scientific institutions within the executive branch that have weighed in to say, yeah, this is really an example of violation? Because there are stories here in the US where political appointees will often redline scientific reports, right, in ways that are against the kind of the peer-reviewed scientific consensus. And I want to say that is distinct from other examples where, look, the committed environmentalist within the EPA just really wants the environment to be saved. And so it's on that basis that they engage in these tactics to try and defy and stymie the efforts of Scott Pruitt and the duly appointed agency officials that are contrary to what he or she wants. And I think that while difficult sometimes to isolate in particular cases, right? Because even when we think of our own motivations, we might think that we're acting in good faith, but we could actually be acting on our personal preferences. In other words, it's not a coincidence that the left and the right often celebrate different versions of civil servant disobedience. Okay, it might be difficult again to actually know what's motivating oneself. Conceptually, I hope we can recognize that these are two poles of action. Disobedient action of the civil servant. And so I was just trying to, so the paper's just trying to isolate one category as more valid than the other. And I don't know, perhaps your question is motivated by, the idea of insubordination or the word insubordination, which I do want to apply to a context where people are just disagreeing and refusing to implement something just because they disagree with it. And I think that is not justified in the administrative state. Whereas I think if there is some good faith reason to think that there's political reform that could occur, there is more space for it. And in case it wasn't obvious too, like I am not at all celebrating civil servant disobedience. I actually think it's a really pernicious development. I hope it gets stamped out. That's my last comments about trust being restored. And I think that to the extent it's justified at all, it's very, very narrow. Okay, now let me onto your second question, although I welcome discussion or deliberation on the first. On the second, I think your criticism is, or question, however you want to frame it, is a real one, because I think my account of civil servant disobedience has drained the moral underpinnings that are familiar in the civil disobedience context. You've given us the example of My Lai and all of the these situations where it's just clear that radical reform and resistance was justified. And in talking in legalisms and process, right, it really kind of changes the ethos of the behavior that we're talking about. And I think that's a real observation. And I think you're right to locate that and to identify that. That said, I think that look, administrative law is boring. What I mean by that is it tries to depersonalize, tries to rationalize, it uses neutral principles to try and again justify these actions by unelected bureaucrats. And I think that's what distinguishes to me the civil servant disobedience context from the civil disobedience context, where I think those notions of, you know, passionate protest and morality are so much more resonant. I feel like in the administrative civil servant disobedience context, there is at least reasoned for that dispassion, for that draining, if you will, of some of those more kind of radical, morally laden judgments, because the aims of, or the pull of managerial authority is so much stronger in the bureaucratic context. So that's why I at least in the paper, I'm still thinking about this, you know, I tend more in that direction, but I recognize the costs of doing that.
On that last point about what's permissible and what's not in a bureaucracy, it strikes me that certainly in the United States, you have the debate about rationality review, State Farm review for arbitrary and capricious decision making, and that there's a discomfort with decision makers, even elected or accountable decision makers, taking decisions on partisan or ideological bases. So I can see that maybe feeds into to the your last response as well, and that's a trend you see in common law, in other common law jurisdictions as well. But Professor, on the same theme, Professor Mark Hertog from the University of Groningen, who kicked off this series brilliantly earlier last month, suggests that your central point of departure in your discussion of civil servant disobedience is the model of a top-down bureaucracy. But he wonders whether this doesn't frame your approach about what is or is not allowed. So that's one question. And if we start from the proposition that, and you did say this at one point, that agencies, it's important to allow agencies to work in the hierarchical way that they're supposed to work. That's one question. Does this normative position about the desirability of top-down bureaucracy frame what's permissible and not in terms of bureaucratic, in terms of civil servant disobedience? And then the second question is, what do you think about leaving more room for professional discretion for civil servants? Sometimes you might perceive that as civil servant disobedience, but it may also contribute to a more just implementation of laws, for example, in the field of welfare law or tax law.
Yeah, so while recognizing the centrality of hierarchy, I do think it's really important to recognize the bottom-up aspect of an ideal bureaucracy as well. And that's why I call it a reciprocal hierarchy. You know, I don't think it's just top-down. It should be bottom-up. And I see that again instantiated through the procedures that agencies have already developed intra-agency to allow that bottom-up functioning to happen. And these are regularized, institutionalized procedures, again, like these clearance chains that I referred to earlier. And so this is just to say that, you know, that to me is the model of the ideal bureaucracy. It's not one that is top down. And as a result, that bottom-up aspect of it informs my sense of when civil servant disobedience is justified or not. That is, when this process is completely top down, that's when civil servant disobedience is more justified, because no longer is the bottom up information sharing occurring such that political appointees are actually giving civil servant views and information, they're just consideration. I don't want to say just because that's loaded. I just mean they're due consideration kind of within the process. And then as to your point, so bottom line, I don't think top-down hierarchy is kind of the main motivation. It's really reciprocal. That's important, I think, to this picture. And then as for professional discretion, absolutely. I think professional discretion is very important. And I think that it is inevitable. And, again, civil servant disobedience only occurs when there is a clear, well, just a contravening of an executive directive that is constraining that discretion very narrowly. But absent this directive, again, I think professional discretion is just, again, just the normal functioning of administrative agencies. And so I suppose a lot of it will depend on just kind of how ambiguous or clear the executive directive is. And in other words, civil disobedience is the most obvious when there has been a case where the appointee says, absolutely do not give that benefit, or in this program of benefits, do not grant those. But when, it's much more of an ambiguous directive, they say, oh, when it's reasonable, give the benefit. Well, then there is really that room for professional discretion. And I don't mean to suggest that, every exercise of professional discretion is civil servant disobedience, far from it.
All right. Jackson, with the surname beginning with the letter R, asks in the Q&A, and I'm not going through the Q&A in chronological order. I know that Jackson's questions touch on a little bit of what we've just been discussing. So his first question is about he says rules don't prescribe all types of behavior. Cases where the terrain for action is uncertain or ambiguous, public servants may exercise agency to confront those gray areas. This might be perceived as resistance by some agents. So I think the question there is, I suppose, about distinguishing resistance or disobedience from resistance, and sometimes you might have agents outside the bureaucracy who have a stake in portraying a tension between the leaders of the bureaucracy and the bureaucrats. Do we can imagine examples or think of examples from the not too recent past in the United States? And then his second question is whether resistance can only be framed as intentional or deliberate behavior. Well, I think you address this. Your definition of disobedience covers. You explained why you have the definition that you do. And he suggests that the outcomes of certain conduct might be perceived as resistance, but may be an unintended consequence of agency. So we've got a few concepts there. We've got agency, we've got resistance, we've got your concept of disobedience. Is there anything you think needs adding to respond to Jackson's question?
Yeah, well, I think your question very much follows nicely kind of from the previous question, the discussion a little bit about this realm of kind of ambiguous executive direction and, the room that leaves for professional discretion. But I think, I want to just isolate one central theme, I think, of both your questions, which is, it's an important one, which is sort of who decides? Because, a lot of your questions have to do with kind of external actors' perceptions of what is resistant behavior versus kind of the subjective perceptions of the civil servant and the executive. And I think that is a really hard question, that being sort of who should mediate what is justified and unjustified civil servant disobedience. And my paper does not touch on this question at all. It's an open question. For example, we could have different answers, right? We could say, look, it's the courts that should decide this. Courts should use all of their tools of, evidence and so on. Maybe this civil servant disobedience is an invitation for a statute to be written that can be judicially reviewable. Okay, that's one possibility. Another possibility is it's some internal executive branch actor that decides these questions, because maybe the judiciary doesn't understand the mechanics of internal agency behavior, right, and governance. We should keep judges out. And maybe a better office for this is something, like, who knows, the Office of Special Counsel or something like that within the executive branch that should mediate these disputes, or the Office of Legal Counsel in the US, right, that should mediate these disputes. Another possibility, finally, is another, this is related, I suppose, but a little bit different. We have something called the Merit Systems Protection Board. So I saw a question about whistleblower statutes, so this is relevant, where now you have an independent agency that, while vacant, many of it, much of the time, the Trump administration, in normal times, right, is a professional independent body to be deciding these disputes. And it's kind of a hybrid in some ways of a court and an executive branch, because it's the multi-member nature of the agency maybe makes it more deliberative. On the other hand, it is an administrative agency, and therefore maybe is more attuned to the dynamics of intra-executive branch give and take and push and pull and deliberation. So I just want to acknowledge that feature of your question, that it raises this question of who decides what is justified and what isn't. And I think that's an important question that's left unanswered.
Right, and that takes you through the whistleblower possibility, and you ultimately might have a board or a court which is determining whether or not a whistleblowing activity is justified. You may have another board or agency determining what civil servants can and can't do. Certainly the situation here in Canada, if you want to engage in partisan political activities like running for office, in principle you can try and do that. You have to go to the Public Service Commission to do that. My colleague John Marquis asks whether challenging a government practice in court would constitute civil servant disobedience. That has happened here. There was a case brought by a lawyer in the federal government called Schmidt, who was concerned that the federal government was not taking seriously its statutory obligation to introduce legislation which is compliant with the Canadian Charter of Rights and Freedoms, rough equivalent of your Bill of Rights. He was unsuccessful in his challenge, but that's the example that springs to mind of someone in Canada going to court. He ended up resigning, Mr. Schmidt. Does court action constitute disobedience? Is that
this is a great question, and one that I have struggled with, because I gave you the example of the ICE officials going to court as an example of civil servant disobedience, but I admit to being torn about that, and here's why. So the argument that it is not civil servant disobedience is that it is a lawful means of expressing dissent in the US. I imagine in Canada as well. So in the case that I am thinking of, it was actually the union of ICE agents that brought suit. And as a result, I think one could argue that this is just a normal course of dissent that is the precursor to civil disobedience. In other words, it's not civil disobedience because, look, these are the sanctioned channels that we have developed for dissent, akin to going to a congressional committee, going to an inspectors general, going to the Office of Special Counsel here in the US through the whistleblower statutes, right, to express the dissent. That would be the argument that it is not civil servant disobedience. Now, here's the counter argument, and here's why I thought to include it. And the counter argument is that, to me, it is such a breach of the norms that govern professional civil servants to openly flout and sue your own administration. And I don't know how much of this is cultural. I suspect it's not. In fact, I suspect that the culture is even stronger in Canada, from what I understand of your civil service. But I've worked at an agency. Like, it's unthinkable, to me, to think of one of the career staff, saying something, even in a it wouldn't be a press release, but some kind of public statement, some letter. Okay, this has happened in the Trump administration. Signing some letter disagreeing with your political superior. That to me sounds like such a breach of like what is expected of a civil servant, that to then go to court is just another step, right, in that spectrum that made me think it was an example of civil servant disobedience. But I recognize that this example is a hard one, and it's on the border of whether it should count or not. And, just note that, all I've done in this paper is isolated like one form of civil servant disobedience. Like, who cares whether I call it civil servant disobedience or not, right? I mean, there's still the open question in general of other forms of bureaucratic resistance, are they justified or not? But again, the reason I want to include it here is because of the kind of the open nature of the dissent that I included. But I recognize why it might not count as one, depending on, again, it being a lawful channel. And by the way, that's just one other dimension this paper doesn't grapple with at all, because frankly, there's so little research about this in the US, is the role of government unions, because many of the examples of civil servant disobedience here in the States are often taken by unions. Government unions are the ones like writing the letters, engaging in the press releases. And so there's this separation between the civil servant as a civil servant and then the civil servant as a union member that presents a number of tensions that this paper doesn't grapple with.
Yeah, quite a lot of the public sector unions in Canada are very active litigants, I think it's fair to say, and they have that might provide a channel for frustration with certain government policies, and they bring cases to administrative tribunals or to the courts, which are a mechanism for allowing some of that frustration to be vented. And well, that all occurs through a transparent and structured process, which is an important feature. I have one last question from Laura Bowman. Laura's an environmental lawyer with a group called Eco Justice. I say that just to give you some context for the question. And she asks you to comment on the tension between having a politicized bureaucratic head and the internal deliberative process of expertise, science, and norms of administration. And you touched on this a little bit in the paper, the expertise justification for having bureaucracies in the first place, and the extent to which expertise is a lever for pushback. But she asks, isn't this bad for civil service independence, and doesn't it encourage disobedience by eroding internal norms and structures in the public service? In Canada, this has often played itself out as muzzling scientists whose research contradicts government policy.
So, yes, I mean, insofar as, this is one of the fundamental tensions in administrative law and institutional design. And, of course, has been the subject of a number of historical debates about, how we design a civil service in the first place, right? I mean, so in the US, this merit system that we have can't be taken for granted, right? It used to be much more of a spoil system where, party loyalty was the thing that got you the job in government rather than neutral expertise. So this is just to say that, there are two warring visions of, the administrative state that has worked itself out in different formulations, across time, whether, it should be politicized all the way down, and that the way to legitimate administrative action is through elections, and allow elections to be the disciplining stick that again can justify these otherwise unelected administrators coercing individuals. And then on the other hand, people would argue that absolutely not, that, this is what Paul's referring to too, about the tension and, kind of hard look review, certainly something called Chevron deference in the US about when judges should defer to agency statutory interpretation, also invokes both politics and expertise as its justifications, but it doesn't really resolve what happens when there is a tension between those two dynamics, which results in a number of different funny doctrines in under Chevron. So this is just to say that look, as with most things in life, they're trade-offs, right? I mean, having a completely politicized administration, while it could be disciplining. Look, elections could be disciplining. Like, look, elections happen few and far between. It's every 4 years. Is that enough of a legitimation? And certainly we worry about the huge instability in the administrative state when different presidents come to power. We are certainly seeing this here in the U.S., where it's just a complete 180 when a new administration comes to power. And then on the other hand, right, if you have as Roberts has put it, government can function without functionaries, he says, right? Like, do you want, experts? Do you want to be ruled by experts? Is there such a thing as expertise? And I think that, this really comes to a head when we're talking about this nebulous category of science policy. That is to say, these questions where, science doesn't always give us a definitive answer, and yet decisions have to be made under conditions of uncertainty and of contestation about, exactly what the science tells us. And here, I think some people would argue that, scientists don't really have anything to say when we make the decision. There has to be some kind of politically appointed official that is making the decision in this realm. So, I wish I had I would have solved the puzzle of administrative law if I had some really great answer, but I recognize that this is a huge tension that works itself out in funny ways. And I'm going to again allude to what Paul said, about this suggestion that's been made in the scholarship here that, hard look review should actually take into account political justifications, because without taking it into account, agencies are forced to kind of bend the science to justify a decision that really wasn't a result of any scientific change or new discovery. It was just that a new president came in power and judged the uncertainties differently, and therefore, resulted in this new agency decision.
Well, thank you very much, Professor No, for a fascinating presentation on a fascinating and thought-provoking paper. And thank you as well for being so generous with your time and responding so patiently and with such reflection and nuance to the questions that were posed. Richard Clemens says thanks as well, and sees similar trends at the international institutional level. And of course, we didn't really allude to that, but thinking about the current state of things in the world, there could be room for disobedience in some forms or not in international institutions as well. So it only remains for me to say thank you again to Professor No, and thank you to everyone who's attended these sessions. I'll be back next year on a theme yet to be identified, and in a format which is also yet to be identified. But I hope you've enjoyed this series. We've been really lucky to have had such wonderful speakers like Professor No and Professor Hertog and others. So it's been a real pleasure, and I thank you all, and hope to see you again on some forum in some form in the near future. Bye-bye.